Hi, I'm Courtney Ross. I'm a VA-accredited attorney here at Green & Maruzak.
And I'm John Kent. I'm a VA-accredited claims agent here at Green & Maruzak.
And today, John and I are going to be talking about survivor benefits. So, John, when a veteran passes away, it's obviously a very difficult time for the veteran's family. Part of that may also include new financial concerns in light of the veteran's passing. VA does offer survivor benefits to potentially help the survivors of a veteran financially. One of them is known as indemnity or dependency and indemnity compensation, what's often referred to as DIC. This is a benefit for the survivor, meaning it's a payment made to the survivor on a reoccurring monthly basis once it's granted. So I want to start by going through some of the requirements for DIC, starting with the certain circumstances and disabilities required of the veteran's death in order for DIC to be potentially on the table as a benefit for a survivor. So can you walk us through some of that?
Yeah, certainly. So in order for a surviving spouse or surviving dependent in general to be eligible for what Courtney referred to as DIC, there are some qualifications that the veteran has to meet. One is if the veteran's cause of death was due to or complicated by a service-connected disability, they're eligible for the DIC benefit. There are also some secondary qualifications that the veteran that the eligible dependent is required to meet for the DIC benefit. The veteran either had to have passed away while on active duty or had been rated 100% totally disabling for a period of time. First, and probably the most common we run into, is a veteran who had that 100% disability rating for at least a 10-year window, 10-year period. Another that we see a fair amount is a veteran who was rated at 100% disability for 5 years immediately after their discharge from service. And lastly, another one is a veteran who was a prisoner of war, a POW, who had that 100% rating for at least a 1-year window following their discharge from service.
Yep. So in the veteran only has to fall into one of those categories to potentially make the survivors eligible for DIC. I would say probably the most common one that we deal with in our cases is trying to show that the cause of death was related to a veteran's already service-connected disability or a disability that might be pending or you can file for to establish it and get it linked to service. So it might not be service-connected at the time of death, but if we can establish that it should have been a service-connected disability, DIC would still be on the table. So, John, we've covered some of the circumstances around the veteran's death that are required for DIC. Let's get into who is an eligible survivor. So there's three categories, a parent, a child, and a spouse. Mm-hmm. Can you take us through the specifics of those?
Yeah, certainly. So if you are deemed to be an eligible spouse, you would have had to have been married to the veteran for at least a 1-year period prior to their time of death, or if you were married to the veteran while he passed away on active duty. If the veteran was unmarried, you would look to be, potentially an eligible dependent. And that generally falls into one of two categories, as Courtney mentioned. One is either a child under the age of 18 or 18 to 23 in a VA-approved higher education, 18 to 23, full-time, or if you fall into what VA deems as a helpless child. Essentially, the dependent developed a permanently disabling condition prior to the age of them turning 18. They would still be, even if they were older than 18 or older than 23 outside of school, if they're deemed to be a helpless child, they're still eligible for DIC benefits as a result of the veteran passing away. And the last one is a parent, specifically a financially dependent parent. But however, please be aware there are income limits to what the VA deems a financially dependent parent.
Yeah, thank you, John. That's exactly right. And there's some nuances to some of those categories, but at the general level, that covers who is considered an eligible survivor for survivor benefits. Now, in order to file for survivor benefits, there's a specific form that needs to be filed with VA. Like many other benefits that VA requires certain forms for. John, what is the form that survivors need to be aware of for filing for these benefits?
Yeah, certainly. So if you do wish to file a claim for DIC benefits, you do have to submit a completed VA form 21P-534EZ form.
Yes. And now I mentioned in the beginning that the a grant of DIC benefits is a reoccurring benefit for the survivor if granted. The rate changes year by year, but John, what's the current rate for a DIC grant?
Yeah, certainly. So as of December 1st, 2023, the rate for an eligible dependent in receipt of DIC benefits is $1,612.75. Please be advised that if the veteran was service connected at that 100% rating for a period of 8 years prior to his death, there does exist additional financial compensation, what VA refers to as a DIC kicker.
And now we mentioned the form that needs to be filed and what the rate is. As far as effective dates go when you file for DIC, how far back could it possibly be granted?
Yeah, certainly. So there's two main umbrellas that can fall under. One is treated as any other claim form, the date that you filed for DIC benefits, or if you did file within 1 year of the veteran's passing, you are eligible for that retroactive pay back to the date of the veteran passing, provided it is within 1 year.
And that's important because if a DIC grant, if it takes the VA 2 years to grant the benefit, that survivor would be owed the 2-year back pay of that $1,600 potentially plus payment that John was mentioning. So we've covered DIC. I want to also talk briefly about accrued benefits and substitution. So accrued benefits are benefits or money that was owed to the veteran at the time of his death. So the most straightforward example of that is a pending grant that hadn't yet been finalized at the time of the veteran's death for, we'll say, a back condition. It was pending. There was a drafted decision, but it hadn't yet been finalized. The veteran passes away. That survivor would be owed that accrued benefit that was due to the veteran, just not yet finalized. Now, if a veteran had claims or appeals that were pending with VA, so VA hadn't yet made decisions, there were no drafted decisions, what option does a survivor have in that scenario? If there were claims pending, unfortunately, the veteran passes away, what are their options?
Yeah, certainly. So if you are in that scenario where the veteran does pass away, for accrual purposes, you can essentially step into the veteran's shoes. You do have to meet one of those eligibility requirements as spouse, minor child, or child 18 and 23 in school full time. But it does allow you to essentially step into the claim on the veteran's behalf and proceed as though you essentially were the veteran throughout the entire claims process, increase rating. The main thing there to be aware of is that you cannot file any new claims after the veteran's passed away. It can only be, as Courtney mentioned, claims that were existing or pending when the veteran passed away.
Right. So this is what is often referred to as substitution. You're substituted in, as John said, to really just step into the shoes of the veteran to continue any claims or appeals that are already pending. Now, as John said, you can't file any new claims. And if those benefits are granted, the survivor wouldn't receive the monthly disability compensation payment moving forward, but they would receive any of the back pay that was owed to the veteran in light of that grant of benefit. So that's a distinction that's important to keep in mind. And VA also has a specific order of succession, essentially, for who can be substituted in, starting with the spouse, the living spouse of the veteran, and then it goes from there. So they have more specific rules for substitution than who can apply for DIC. Similar to DIC benefits, there's a form that's required to substitute in a survivor. John, what is that form?
Yeah, certainly. So just as everything else, VA loves their forms. If it is a request for substitution of the claimant upon the death of the claimant, you need to file VA form 21P-0847.
Yes. oftentimes along with that 534 form as well, if you're pursuing the benefits.
And then they'll also look to just, if you are looking to be substituted in, VA is going to require some additional documentation to essentially verify that you were the spouse of the veteran. Frequently, we'll look to obtain a copy of a marriage certificate to essentially just verify that the person looking to be substituted in is a valid, eligible individual for substitution purposes.
And one really important thing is that there is a deadline to file these requests to be substituted in. How long does a survivor have to make this request to VA after the veteran's death?
Yeah, so if you do want to be substituted in as an eligible claimant on behalf of the veteran, you do have to file that form within 1 year of the veteran's passing.
Yes. So that's a very general overview of survivor benefits. There's a lot of intricacies, obviously, that go into it, and it can truly vary by, case by case. So if you have questions or want more information, feel free to reach out to us here at Green & Maruzak.